Code application for stay, my lord. It's not appearing in the list. We have filed before 2 months. It has been, my lord. The file is filed on 15/6/2020.
Group 6 matter.
Service mark.
Group 6. Item number 1.
Ticket number 1, my lord, I appear for the petitioner.
Lord, I appear for the state.
This is the case, my lord, the petitioner, Mr. Lordship, got a favorable order from the learned tribunal. And my lord, thereafter he filed one contempt application, my lord, with the stipulated time as directed by the tribunal was over. Now, my lord, this being the situation, I'm forced to come before Lordship, my lord, for implementation of that order.
What is the direction?
But there's a direction to, my lord, refund me the amount which has been deducted after my retirement from the retiring gratuity. But if your Lordship sees the order, 63. Well, this order is said to be non-complied with.
You're representing the state respondents. Accountant General is also party.
Cost item, but as if a content limit of the cost has been, we have been made a partly incorrect. Point number 7. But whether it is participant at this statement, it's point number 7 and it's 4.
Yeah, yes, up to 4 you have said respondents, and 6 and 7 you have said contemners. Why?
Well, that was the cost title before the learned tribunal, my lord. I cannot change it, my lord. As because what was there in the tribunal, it is as it is to be before Lordship, my lord. I cannot change it or make it.
Contemner stroke opposite party. So that is a position showing before the tribunal.
My lord, they were the contemners, my lord.
Where is the application before the tribunal?
My lord, your Lordship kindly take note, my lord, that is at page 45. Starts from page 45. My lord, the array of contemners, if your Lordship takes up, my lord, it's from page 49. But there are 2 contemners. What is there in the tribunal, as it is, I made it before your Lordship, my lord.
No, but here they will be contemners stroke respondents.
It should have been, my lord. It should not be opposite party. It should be respondent, my lord. Leave maybe granted, I to rectify that party.
Anyway, we'll see. File your oppositions. There is a
that it is for the implementation of the order of the learned tribunal. But the times that the order of the tribunal speaks about some responsibility on the part of the state.
correct. So let them file the opposition.
Over here, the state respondents is to do the needful.
What is the direction?
What you will kindly see.
It's 63, my lord.
Refund of recovery amount within 3 months.
Now, this recovery has to be calculated by the state respondents.
Very well. So let them file an opposition.
Only the recovery of the state amount has to be done by.
Hey, we are not in a contempt proceeding. File your oppositions. We'll see. It's not a contempt proceeding. We are taking it up because the tribunal is not there. Let's see, not functional.
Lord, may I only humbly submit this?
You don't want to file opposition.
Lord, may I come back with this instruction as to whether this order, my lord, has been challenged by the state or not. If they have accepted the order, then, my lord, possibly, my lord, I would insist upon my clients to release this amount and come back to my lord, informing this.
It is submitted by the learned.
Then it is only logical that we pay.
Yes. Otherwise, if you are challenged, then of course thing will change. Let's see.
I'm deeply obliged to my.
Yes.
I am also covered by your Lordship's order exactly on this point.
Let's
matters with it.
Item number 2.
I am appealing for the petitioner, my lord. My lord, that is.
My lord, only, my lord. With regard to other matters, my lord, today is my daughter's birthday, my lord. I will be leaving the court, my lord. If my matters may take up.
Yes. Oh.
My lord, in item number 2, I am appearing on behalf of the state along with government pleader and my junior learned friend, But I have not received the yesterday only.
What
it
is
has
the
been
date of
allotted.
filing of the OA, madam?
My lord,
What is the date of filing of the OA?
my lord, in 2025, I have filed the OA.
Date, show us the date.
That date is not there in my OA.
No, you'll have to give us the date, otherwise, see, we are not entertaining the matters which have been filed after the tribunal became
No,
non-functional.
my lord, it was filed when the bench was present at that point of time.
You are sure?
Yes, my lord. After that, after 1 month only, he retired from that bench. So the matter was been placed before the register. As that time, it was a rule that first register will take up the matter, then it will be placed before the bench.
This is the third order. Yeah, but the copy now is.
Just give us the date. Please give us the date.
Sure.
You ascertain the date. We are adjourning it not today. You give a copy in the meantime. Yes.
Item number 3.
Time for the appellant, my lord. My lord, kindly fix the matter any day next week, my lord, at 2 p.m.
Now a new application has come
Yes, my lord.
for production of the additional document in the midst of the argument when the appellant.
Which matter?
So this was
This is
a challenge from a dismissal for a specific.
Oh,
Yes, Mr. Sen was arguing, my lord. Lord, kindly keeps any
Since
day.
the arguments were made threadbare, I was in the midst of my argument. Now an application has
anyway,
come.
we are not considering the application right now. If they have filed, we'll see.
Very well.
As played by the learned advocate for the appellant.
Say this, Malad, for the last few occasions, Malad, Mr. Shen could not come, Malad, due to various.
Perhaps there was some personal difficulty.
Yes, Malad, there were some personal difficulties. Malad, I believe, Malad, Mr. Shen will have difficulties in the mornings. So, Malad, if your lordship keeps it in the morning, in the next day, inevitably, Malad, a request for adjournment will be made, and I can't oppose that request.
Wednesday we have 2 p.m. available. Then we'll have to check. It is available then only. This will take some time.
On Thursday.
Thursday.
6th. Grateful, Malad. 6th August. Grateful.
Let it be on Friday, my lord. Today's. Or my lord,
Tomorrow,
next week, any day, my lord. Any day. At
No. If there is a matter, next week then. Monday, next after that.
Monday, 10th August. 10th August at 2 p.m. Grateful, Malad.
Item number 4.
So, Mr. Syed Nurul Arifin is appearing for the appellant due to his ill health. He couldn't come to court today. I'm praying for not today, Lordship.
Not today.
I am for the alleged contemner.
For the
Alleged contemner.
let us see. Not today. We will come tomorrow. Not today. What is this one? Not today.
Item number 5.
In this matter, I am appearing for the read petitioner respondent. The matter has been taken long back. Today in the morning, I have tried to contact with my clients.
Let's see. Let them make their submission.
My lord, Mr. Shoma Mujumdar is leading me in this matter. My lord, he's on legs before another court.
Who is the appellant?
My lord, I'm for the appellant. Mr. Shomo Mujumdar is leading me in this matter. But he made submissions on the last occasion, but the petitioners were not appearing. My lord,
In fact, the previous occasion, your lordship has recorded that by virtue of the judgment by the Honorable Appeals Court,
Yes, yes.
uh,
Nothing left in this matter.
the appellant is not amenable to the rejudication. In fact,
So why it is pending?
it was
Lordship, my lord, on the last occasion, my lord, the respondents were not appearing. It was only us who were appearing. For that
Still
reason,
they are not appearing.
my lord, they are, my lord.
We are. I did not notice I missed the list actually.
So then appear, we'll take it up.
Yes, yes, yes. Now, my lord, that's today I have in the morning I have talked with my clients. Now, my lord, they
Please give your appearance. Mr. So-and-so appears for the respondent. You have got it.
in this matter, lordship, I have nothing to say because it is
We'll see.
no.
Item number 6. Where the respondent?
That is Mujumdar. কোথায় রাখবে?
None appears on behalf.
Weeks. 26.
Item number 7.
7, I am
As
for
for
the
the
appellant.
filed affidavit on behalf of the state, lordship, they kindly give me this. And one.
Item number 8.
Lordship, my senior is appearing on behalf of the.
In this matter, I am appearing for the CISF led by Mr. Dheeraj Trivedi, my lord.
CISF. What is it?
Lord, the petitioner consumed alcohol outside the premises. Thereof, my lord. Lord, I am led by Mr.
Apologize, Lord.
My senior is on the way. He's coming.
वहां बोलो पास ओवर लेने का करें I've got two pertinent points of law. Facts I will delve later, my lord, subject to correction.
There is no cross objection.
Lordship, it was decided. This is my first contention, which I want to put before very humbly before my lords, is that I was not given an opportunity of dealing with the writ petition. And the Honorable Single Judge went on a pretext that we are reviewing the order of censure granted under 37. Whereas the proceeding were a new proceeding under section 36, which was on the basis of new findings, unearthing more information, wherein we started a fresh proceeding and the fresh charge was framed. Now, Lordship, there are two pertinent points of law which I intend to put before my lords. First of all, my lord, audio alterum partem. Secondly, Lordship, whether on the concept of two FIRs, because it is a cause of concept double jeopardy. Whether two FIRs can be registered over the self-same event, not cause of action. Event, not cause of action. Second. Thirdly, Lordship, the Honorable Single Judge erred in not appreciating the proper facts because the Honorable Single Judge misdirected himself to perceiving that this particular process or the proceeding, which was based on a new charge, memorandum of charge, was basically a review, suo motu review of a censure given to the respondent in this particular case in a previous proceeding which arose out of the same event. Now, my lord, may
পার্টি সাবমিশন করছে উজ্জ্বল সরকার এটা অ্যালকোহল করেছে খেয়েছিল
কোনটা এটা
উজ্জ্বল সরকার হ্যাঁ এটা পার্টিটা দুটোর সময় ফিক্সড
পার্টি দুটোর সময় I apologize for that confusion my lord.
That's why we were keeping quiet.
My lord, I render unqualified.
Yes. Anyway.
Unqualified.
No, please.
Kindly not take me amiss.
No, please.
New post, new jobs, and motley matters.
We have not said anything.
Then, well,
we are just wondering. We are trying to look.
I had heard it from in the stories of the bar regarding the honorable seniors, I would say very revered seniors of my bar, that they went and they started arguing a case for a different matter, and then they were told by the juniors that this is not. So maybe I have not reached that level as far as their capability of jurist was concerned, but maybe in age, they were. My lord will kindly.
So this arises out of a charge memo, as we can see from the record. And there is a finding, and the single judge perhaps has only found the punishment to be shockingly disproportionate.
That's the.
Therefore, we asked at the very outset: is there a cross objection or appeal also?
No, there is a
no. Okay, then let's proceed.
I was trying to argue before my lord the matter which has been fixed at 2 by your lordship. That is the I got confused between the matter which is now and well, that is the.
So there is a finding that he locked the gate under intoxication.
My lord, and there is a finding, and he did not oppose to that finding. Though in this particular way, he has taken point that he was not granted a chance to cross-examine, and the procedure of giving documents were not followed, but all those were given. But I start from the particular precinct where he has been accepted most of the, and he has not appealed against it. Now, lordship will kindly see the order impugned. My lord kindly takes the.
So interference is only in the quantum of punishment, limited interference.
Now Lordship will kindly see.
So what is the allegation proved? He was intoxicated
He was
and he locked some gate. What is that gate?
My lord, exit gate of the airport he locked, and then he created a situation which was not akin of an armed forces officer. Well, the concept was this, that whether he was on duty or not. And Millard, apart from that, so many statements were made by him, but it culminated that somewhere or the other within the four corners, Millard, he accepted. So, Millard, therefore, I'm trying to threadway read the judgment before your lordship. If my lord allows me. My lord will kindly take up the judgment. Impugn. So the first ballot we had initiated.
Yes.
Malal will kindly allow me to place the first paragraph of the impugned order. The petitioner, a concept which will give a basic the background as to what the charges were on. The petitioner, constable with the Central Industrial Security Force, posted at Imphal Airport, challenges his removal from service following a departmental proceeding initiated under Rule 36 of CISF Rules 2001. He was charged with gross misconduct and indiscipline for alleged consuming liquor outside the airport premises, scaling a locked exit gate to enter the airport, creating a public nuisance and misbehaving with the fellow CISF personnel, acts said to have tarnished the force image. This is the basic. Now, Lordship will kindly allow me to place paragraph 2. The petitioner contended to have been falsely implicated to shield misconduct by the officers of his unit. He alleged that he was assaulted to his quarters in his quarters while resting after duty, rendered unconscious, and then framed using fabricated evidence, including a medical report allegedly procured by pouring alcohol on him post-assault. He asserted that critical statutory provisions and principles of natural justice were violated, including denial of key witnesses' testimonies, failure to produce the medical examiner for cross-examination, and rejection of requests to change the inquiry officer. He also claimed that the appellant and revision authorities relied on biased reports and prepared behind his back. These were his allegations. Now, Lordship will kindly see. How the Honorable Judge has dealt with it. Many allegations were there, Lordship. If my Lord wants, my Lord, I may read it in a slipshod manner. Then
Maybe not required. If they had come in cross appeal, the issues may have been relevant. But the limited interference by the Red Court is in quantum of punishment. We are just trying to find in the judgment where the learned single judge has held.
No, I'm placing that.
That the findings of the disciplinary authority or inquiry officer are not to be interfered with.
My Lord, kindly come to paragraph 33 of the impugned judgment. Thank you.
No, because in 34 she says if established. So where is the finding that it has been established and that it is correct?
Yes, my Lord, I'm coming. If my Lord allows me to place the judgment from paragraph 31.
Yes, we are looking at it.
The petitioner was, as aforesaid, denied the charge memorandum dated, Lordships have got it?
Yes.
Dated 4/4 2011 under Rule 36 of the CIS, alleging on 6/2/2011 he had sealed a locked exit gate of Imphal Airport, being inadvertently and misbehaved with fellow personnel residing in the airport colony. The petitioner opposed to have been forcibly withdrawn from the barracks by senior officers and assaulted, thereafter implicated in fabricated incident involving intoxication. He sought production of the preliminary report, statements of relevant witnesses, logbooks of the transport vehicle, and other contemporaneous records. The records revealed several of such demands. Documents are either not supplied or not relied upon in inquiry. Although the inquiry officer allowed the prosecution to summon a contractor as the court witness, the petitioner's request to summon material witnesses who were allegedly present in the location was rejected. The fact-finding report prepared by one Atul Sankar was neither disclosed nor supplied to the petitioner. In derogation of 36(18)(b), the appellate revisional authorities affirmed the punishment in a mechanical manner without addressing these procedures. Now, Millers, the scope of judicial review in disciplinary matters is circumscribed. The writ court does not function as an appellate forum for reappreciation of evidence. However, where procedural irregularity patent on the punishment imposed is shockingly disappropriate, interference is not only permissible but necessary to prevent the miscarriage of justice. So the Honorable Single Judge went. She did not take into consideration. She has said that it is disappropriate. In the light, now Lordship will kindly see. Consumption of alcohol while off duty, if established, constitutes misconduct in a disciplined force like CISF, which demands highest level of discipline and regimented conduct. The act of sealing the locked gate while intoxicated is not only an error of the in judgment, but borders on reckless behavior, which is unacceptable. Otherwise, also could have resulted in his own peril. However, there is no allegation of violence, physical harm, breach of duty hours, or permanent dereliction of service, and with regard to the third person pertaining to the instant memorandum of charge issued against the petitioner. In Ranjit Thakur the Supreme Court held that the punishment must not be outrageously disproportionate to the nature of misconduct. The principle of proportionality, as affirmed in B.C. Chaturvedi versus Union of India and so, empowers the court to interfere with the punishment where it appears to be emotional, arbitrary, or excessive in its impact. Considering the nature of misconduct, absence of violent or insubordinate act, and procedural lapses during inquiry, the punishment of removal from service does not appear commensurate with the misconduct proved. Accordingly, now Lordship will kindly see. Now, my lord, what I intend very humbly to put before my lords. My lord, if my lord kindly takes up paragraph 33 onwards, 33 and 34, it has been held by the Honorable Single Judge that these acts or events or the allegations which have been put against the respondent tantamounts to gross misconduct. She also comes to her ladyship also comes to a finding that
we are not able to find such a finding.
Well, that is not there, my lord. I am saying, my lord, what I am trying to impress upon my lord is that the procedural irregularities, because my lord, the culminating paragraph, which actually is acting as an alibi to the final judgment that the impugned order passed in a period with set-asiding order, says only this. That is paragraph 36. Lordship will kindly see the fourth line. It appears to be emotional, arbitrary, or excessive in its impact. Considering the nature of misconduct, absence of violence, and insubordinate act and procedural lapses during inquiry, the punishment of similar datus, the Honorable Single Judge has come to this finding that there is absence of violence or insubordination act and procedural lapses during inquiry. Now, Lordship, first a question I am putting to myself. Violence was there, which we have mentioned in the memorandum of charge. Insubordination in being in an intoxicating state, jumping over the exit gate and then creating a ruckus in public does tantamount to insubordination. Now, the only thing which I intend to show put before my lords, for my lord's scrutiny, is what were the lapses, procedural lapses during inquiry. In my respective submission, there were none. So, lordship, and since there has, in my respectful submission, if there is no procedural lapses, then, my lords, the other 2 points on the basis of which the Honorable Single Judge has come to this finding that it does not commensurate the punishment which has been given, in my respectful submission, is an error in law. Okay. बोलो ना पासवर्ड लेने at least हमें बोलेगा कोई यार बोलो हमें बोलो he's on the next October, but it's an important matter.
Why did you say that you were not given an opportunity?
Not here. No.
Oh, that is in that case.
That is my argument with regard to 2 o'clock matter. That is the difference. My lord, I was totally agree. My lord, if my lord,
Where is the finding of the learned single judge that there was this procedural lapse which makes the order of the inquiry officer report untenable or the disciplinary authorities order untenable? In 36, the learned single judge says due to procedural lapse, punishment is not sustainable and then remits the matter only to consider the quantum of punishment. So if there is a procedural lapse, where is the question of punishment?
Can you come to page 2 of the order, madam? Page 2 of the order. Paragraph 3.
So again, we are asking, where is the finding that the inquiry report is bad for such and such a reason?
One will come.
Yes.
Paragraph 3. My lord, paragraph 3, my lord.
there are submissions made by them and submissions made by me. The culminating paragraph starts from paragraph 33, where the Honorable Judge has.
Therefore, we are asking.
As to why
we are asking him to show, because he is the beneficiary of this order. Where is the finding regarding the inquiry officer's report being vitiated on such and such ground?
Come to point.
Which procedure? Yes.
My lord.
My lord, still he is my lord,
The petitioner
back within 1 minute. Yes. I
Yes.
apologize. Let me call. তুমি থাকো আমি কি করতে
My lord, this is not a case as has been presented by the respondent.
No, he has not. We are
My lord,
on going through the order.
My lord.
It is the query of the bench.
I'll come, my lord.
Please show us where is the finding
I'll come, my
that
lord.
for such and such reason the finding of the inquiry report is
I'll
unsustainable,
come, my lord.
or that for such and such procedure lapse the proceeding is vitiated. Where is that finding?
I'll come, my lord. First, my lord, connect partner, my lord. 1 minute, my lord. Petitioner on completion of duty, he was sleeping at his quarter.
We are not,
That is most
we
important.
are not sitting in
That is
appeal.
most important, my lord.
No, that's not. We are not sitting in appeal.
No, how can appeal? Mr. Atul Shankar was,
We don't know. We don't know. We are not going to scrutinize
my
those
fact,
facts.
my lord, this is fundamental of my lord, that one inquiry
We
conducted.
are asking you to show the finding of the learned single judge. Just come to that. Otherwise, what is the question of setting aside the order?
My lord, I'll say, my lord, unless the,
There has to be a finding.
my lord,
Then we'll see whether the finding is sustainable or not. If there is no finding, why should we look into anything? So show us where is the finding that for such and such procedural lapse, the inquiry report is vitiated. And therefore, the disciplinary authority's order collapses and the appellate authority's order is also
my lord,
unsustainable.
then I'll start from paragraph 3, my lord.
No, paragraph 3, there is nothing like that.
He records,
Please don't read the entire judgment. We are asking you to show which paragraph.
there is violation of principle of natural justice, paragraph 3.
Where is the finding?
I'll come, my lord.
No, you do that first, then we'll go to the other facts. Without returning the finding, how the order can be interfered with?
My lord, these
Please show the finding.
Even my lord,
Will not unnecessarily hear the entire thing all day. Which procedural lapse prompted the Honorable Single Judge to hold that the inquiry report is unsustainable? And where is that finding in the judgment? Anywhere in any paragraph.
I'll come to paragraph 10. My lord, not, my lord, I have to go all the paragraphs.
No, you don't have to. You show us that only. Why should we read the entire paragraph?
Because every one of
Sorry, please show us. Please show us where is the finding. We will not go through the entire judgment.
finding has not prepared just in one paragraph. In every paragraph, some of the has been given.
Any one you show.
I'll come to paragraph 9.
Page?
Paragraph 9 and 10. No, 8, 9, 10.
Start from 3 then. You start from 3 then.
No, but
Sir, you have to answer the court's query.
My lord.
Once you answer the court's query, we will hear on whatever point you want to submit. We can't consider the entire thing as if we are hearing a writ petition. This is an intra-court appeal. The judgment of the learned single judge interferes with the findings of the disciplinary authority. It remits the matter for a limited consideration on the quantum of punishment. What is the basis for this consequential direction that we are trying to see in the judgment itself? Then will come an issue whether that finding is sustainable or not. If there is no such finding, then what are we to look into?
My lord, unless I am given opportunity to place my lord, these paragraphs, what shall I do, my lord? I cannot.
Yes, so we are asking you
My lord,
again and
these
again, paragraph 8 and 9.
are the submissions, my lord, of the writ petition.
We don't want to see your submissions. Therefore, we are not allowing you to read that. Our specific query is where is the court's finding? And we are giving this opportunity to you because you are the beneficiary of this judgment. We are giving you an opportunity to point out that, yes, look, here is the finding. And then we'll proceed to say whether it is a sustainable finding or not.
My paragraph 19 may please, my lord.
Yes, please.
The petitioner was employed as constable in the Central Security Report, was a relevant point of postage and as employee airport. He was served with charge sheet of the charge. The deputy of the sheriff, the charge labeled against him was alleged that on 6 approximately it was allegedly under the influence of alcohol consumed outside the airport premises, possibly entered into security area of the
These are all your submissions.
This is the judge's submission. Submission is what the judge starting.
No, this is your submission.
The petitioner was employed in constable duty.
This is all your submission. Union of India submission starts at page paragraph 25. Then their submission goes on till (27), and then the Honorable Single Judge considers some judgment.
Paragraph 23 may start, my lord.
23.
My lord.
This is your contention.
No, this is grave procedural lapses are highlighted, including the violation of principle of justice for incorporation further unit was denied with valid justification, thereby.
You are reading para 23.
Madam.
Please read.
Grave procedural lapses were highlighted, including the violation of Rule 3610B3, which mandates the production of documents.
Highlighted by whom? These are your submissions, sir.
My lord.
These are your submissions.
Taken into that has been taken into consideration.
Where is the finding? Now you see paragraph 34. Consumption of alcohol while off duty, if established, constitutes a misdemeanor. If established.
Yes, madam.
So where is this fact that it has been established or not established? Where is
But
the
that
finding?
was not established, my lord. My lord, paragraph 20, my lord, here is something, my lord.
20 is your
One of the
submission.
tests,
20.
one of the tests to be applied while dealing with the question of quantum of punishment would be, would any reasonable employer have imposed such punishment in light circumstances? Obviously, a reasonable employer is expected to take a consideration measures, magnitude and degree of misconduct, and all of relevant circumstances and exclude irrelevant matters before imposing punishment.
The fact pending report of was neither disclosed nor supplied to the
I have to remit to your discipline of Can you remit it back to the discipline of I'll come to be 30, para 37. Because of the lapses your lordship is pointing out, the learned Singh is having pleased to remit the matter appraised to the disciplinary authority. Can you come to paragraph 37? Otherwise, my lord,
We are looking at it. Please read.
37.
Yes, accordingly.
Accordingly. And improvement must be those passed in papal which are not are sisters insofar as they pertain to the punishment. The matter is remitted to the disciplinary authority for reconsideration of penalty. Such shall be confined with those summary such as withholding imprisonment. But that was not done. Appeal. The petitioner shall be given an opportunity for personal hearing limited to the quantum of penalty. The entire exercise shall be communicated to the relatives from the conservative. During the period the petitioner deemed to be under suspension shall be entitled substitutional. Law, hearing in this order be considered as far as the findings of misconduct. My lord, facts are most important. As has been presented in the memorandum of inquiry, that is not the fact. Actual fact can be viewed from the inquiry report, Mr. Atul Sankre, who belongs to another unit, on the basis of a complaint of the petitioner wife to the Human Rights Commission and other authorities. He was detailed. His report was not considered. And that report has been concealed. Learned signature call for the records, that was not presented. My lord, nothing would be required if you are pleased to direct them to produce the inquiry report of Mr. Atul Sankre. That is only. That is what about that is I will accept.
Whatever you say is to be viewed keeping in background that this order is not challenged by you.
My
This
lord,
order is not challenged by you. The learned single judge order was not challenged by you.
my lord, petitioner is just beggar. He is not in a position to challenge anything. Either he will die or survive, that is upon your lordship. He was placed in such a position, he could not get proper treatment.
See, we are only.
Whether he has actually consumed alcohol or not, no evidence. No evidence.
Where is the finding? We have asked you at least 5 times.
Well, but I'm
You are arguing if you are arguing before the inquiry officer or disciplinary authority. Where is the finding of the learned single judge? No finding returned regarding any irregularity. Order set aside. Consider the quantum of punishment. Wonderful. Therefore, we asked at the outset, did you challenge the judgment? No. What they will consider and why they will consider if there is no infirmity held by the honorable single judge that for such and such ground the order is unsustainable. Now you have not been able to show us. We are asking you to come to page paragraph 32. That is the only vague finding recorded. We asked you at least 6-7 times. The preliminary inquiry report was not handed over, and there is another finding that the witness was not allowed. These are the only 2 findings. How it prejudices you? Nothing. Apart from this finding in para 32, there is nothing. How the punishment is shocking to the conscience? Nothing.
My lord,
we are only pausing for this law because we know the writ petition is of 2013.
His report can protect the judicial system, my lord. Everything. Report by Mr. Atul Sankre. Because all of the petitions are reported to Human Rights Commission, senior officers, and senior officer directed.
Was from the inquiry report that Atul Sankar's preliminary
May lord, come to page 31
What is
of the can 2.
What is it?
Writ petition.
That is the inquiry report.
No, writ petition.
You have a copy of the inquiry report.
Yes, that is there. There.
Is it part of the record, inquiry report? Is the inquiry report on record?
No, my lord. The lordship will kindly speak. As far as the, my lord, let him complete, my lord, I will ask.
No, we want to see the inquiry report. He has not pointed
My lord,
out.
will inquiry report, I am coming.
Not point out anything.
What the judges, honorable judges are wanting us in which case. Lordship will, final inquiry report, lordship will get. Then take that, 107. Lordship, page 107 of the staff.
108. We understand what you are trying to submit. There is till now the only finding of the learned single judge is in paragraph 32. There are 2 infirmities which the learned single judge has taken note of. How it prejudices his case, what was it relied upon or not, nothing is considered. Please examine the report, both of you. Address us on that issue.
Let me understand what has fallen from my.
See para 32 of the impugned judgment.
Well, that is what I am coming on. Para 32, lordship has rightly pointed out.
We don't want to remit the matter now after 13 years. That is the whole point. That's why we are asking you to.
Paragraph 32, my lord, if my lord kindly sees,
What does it say? Please
Also,
read.
the inquiry allowed the prosecution to summon and counter the court witness. The petitioner's request to summon material witnesses who were allegedly present at the location was rejected.
So that is one.
The fact-finding report prepared by Atul Sankare was neither disclosed nor supplied to the petitioner.
So these are the only two informants. Please go through the inquiry report, assess the court, both of you, whether it is relevant to the finding or not.
So my lord is wanting as to whether, well, my understanding of the
To my best ability, I could not find any other wherein any finding has been recorded.
my lord.
If you find, you can still show us.
Yes, my lord.
But at least this much, please show us.
Yes, my lord. What I have understood, I am just trying to reiterate it.
How this informative vitiated the findings of the inquiry officer, how it was relevant, did he lend consideration, was it raised at the appropriate time?
Yes.
All these things just
Yes,
go through it.
yes, my lord. No, my lord. Because my lord, in his written objection, and when we gave him the brief notes, in reply to the brief notes, this Atul Sankare issue was never raised. One.
So therefore, if a preliminary inquiry report is not relied upon, then it was not because. So we are saying, please
Yes,
go through
yes,
the
yes,
inquiry
Lord.
report is not there. Please go through it. Yes. For further consideration, list.
There is no point, no. There is such a so many people this kind of outlaw system. Well,
Item number 9.
next week. I'm grateful.
Lost time for the petitioner.
Petitioner. I succeeded, my lord, in the
Lordship, I am praying for 1 week time, Lordship.
petition. Your lordships were kind enough to direct the bank, take instruction. The order was very specific. 28th July order. If your lordships kindly take pen.
10 July.
20th July, 20.
None appears.
Yes. No, please. There was an order, my lord. The author, my learned friend was directed. 2nd July. 2nd.
Now you are correct.
I became wife.
Earlier you were wrong. Now you are correct.
My correctness is subject to your lordships opinion.
They want a time.
That
They are praying for a time.
I cannot be vociferous because many a times I was. So will it kindly so that your lordship 10th of this month, if it is possible, 10th.
Yes.
10th is all right.
Yes. Grateful.
Charge sheet is dated 29th August, before 1 month before the retirement. And the similarly placed person will was entered.
Mr.
Item number 11.
The listed that.
Lordship, here I am for the respondent. 11. 11. Can fees filed on our behest. Lordship, it's a order for modification of Lordship earlier order because
Made the application.
I made the application. My senior was leading. He has not come to court. There's no brief.
So what happened? Any payments made?
No, actually, Lordship, last CAN 3 was filed on our behalf. It was made for a modification or recall of Lordship's earlier order.
Before we had asked an order so that you should get the dues of your husband.
Lordship,
And you were required to make a pro forma application. Have you done that?
Lordship, we have done that twice before. While making submission, my senior was not.
After 11/5/26, when we passed the order, to ensure that you are paid the dues of your husband, did you make an application on?
We found that it has already been made back earlier. The bench has made a note of that, and they have made their submission. We have annexed that in CAN 3. They have received the document twice, Lordship, in the in the format that is suggested. That was suggested by the
order of 11/5/26 before you.
Lordship.
You are appearing without file.
My Lordship, my senior was appearing. He has not come to court. No file.
Then why you are making submissions?
So kindly make it.
You are recorded an order for your benefit. You are making submissions, trying to put the clock back. You were anxious that you will get the dues of your husband, whatever is due of your husband, late husband. He said that the bank will hand over a copy of the pro forma and you will make an application. If they do this, that's all we are asking you. You don't know.
No, Lordship.
After this order,
After again, no application was made.
There is none to
Entiendo হবে।
Item number 12. Item number 12, Milord, I am appearing for the appellant petitioner, Milord.
I am appearing for the writ petition or respondents.
Milord, in this
is my
matter, Milord,
affidavit in opposition to Milord application for condonation of delay.
Milord, in
That's
this matter, Milord, the leave may be granted, Milord, to use an affidavit in reply because there was no direction passed, Milord. There was only direction, Milord, for filing affidavit in opposition, Milord, to my Section 5 application. So I may be, Milord, kindly allowed to, Milord, file a reply, Milord, to their opposition, Milord.
How many days delay?
Milord, 82 days delay.
This is your application.
Milord, my application is, Milord, CAN 1. Lord, I have explained in paragraph 4 and 5 of my application at page 9.
What was the direction of the honorable single judge?
My lord, the direction, my lord, by the honorable single judge, my lord, was to disclose, my lord, the list, my lord, of my lord, the selection list, my lord, which was not published so far as their allegation is concerned. My lord, Lordship may kindly have a look to my can, my lord, can 2, page 192 is the judgment, my lord, passed by the learned single judge. My lord, the operating portion of the order is at, my lord, page 200. Paragraph 19 at page 199.
How much time?
My lord, 2 weeks time may be granted. My lord.
You are saying 3 months.
I am saying, as per their own statement,
Whatever
that
they say will prevail or the office report will prevail.
my lord,
The delay only of 82 days, you are saying 3 months.
my lord,
82 days is less than 3 months. Don't
they
say
op-
3 months.
my lord, they obtained certified.
Call the next.
My lord,
Item 13.
And for the appellant, my lord, this is no objection brief, my lord. My lord, previous advocate already served copy to the previous state advocate, my lord. Now, my lord, the panel has been changed. So, my lord, I have to serve the copy to new state advocate, my lord. So, my lord, I'm praying for 1 week time for served copy to new state advocate, my lord.
Service is not required. We can proceed without service. If we find merit, then we'll direct.
Paper book তুলেছি?
You have filed the paper book.
Yes, my lord.
See if you are ready.
This is no objection brief, my lord. Kindly praying for my lord 1 week time, my lord. Kindly.
Week. 13th August.
Grateful, my lord.
This item 14.
My lord, I am for the appellant.
On the last occasion, my lord, we have given the report, my lord. And the report was, yes, my lord, and the report was also handed over to the appellant, my lord. May I read, my lord?
It is the RME, DME and RME.
It's there also, it's there in the report also, my lord. Kindly come to page. Kindly come to page, my lord. First is page 15. That is the DME.
That is RME, review medical.
No, detailed medical examination.
Which one?
Are Baba, page 15 of my report.
उल्टा पुल्टा कर
एक ही तो report किए हैं. And the man, page 34 is the RME, my lord.
Page 34. ऐसे देखो हो जाएगी 34 DME space 34 but RME space 15.
वो अपना RME निकालिए ना.
हाँ, मैंने
पेपर same. There cannot be a change in it.
I did not receive the very
पूरा को चेंज कर लीजिए ना, घुरा दीजिए ना. वरना स्टेपल में थोड़ा सा गड़बड़ हो गया. तो चेंज इट ना, घुरा लीजिए, हो गया, बात खत्म.
हाँ 34 निकालिए तो इससे कहाँ गया 34 निकालिए तो कट उसको फाड़ के निकालिए कढ़ाई थोड़ी रहने देंगे ठीक इन लोगों ने जो दिया है ना उस पे जिसमें
Many
My lord.
things have been diagnosed. Not a single issue there, so many issues.
Yes, my lord. I am on the my respectful submission before my lord is in this particular case. My lord will see in the review medical form multiple hesitation mark, scar mark on the left thigh, wrist cut marks. So these all are these marks cannot be classified as my lord the hesitation mark. And second point, my lord will kindly I beseech my lord to kindly come to my.
What is the adjustment disorder?
My lord, adjustment disorder is, my lord.
I have also challenged. Sorry, my lord. I tender my apology. My lord, I had challenged the process of conducting the examination, which is
What
in the
is
paragraph.
what is the adjustment disorder?
My lord, I am. It's a mental disorder, my lord, and it is decided by the psychiatrist, my lord. Kindly come to the first page of my report, my lord. That therefore, my lord, para 4, my lord. There were, my lord, para 3, my lord. In this regard, it is submitted that the appellant was initially declared unfit in DME on account of multiple agitation, scar mark on left thigh, multiple hyperpigment patches on both legs, and RBC 4H oblique HPF in urine. Therefore, on the appellant's record, a review medical examination was conducted. During the RME, the candidate was referred to concerned specialist, namely orthopedic, surgeon, dermatologist, psychiatrist, my lord. Kindly mark the box psychiatrist and general physician for experts evaluation, my lord. The specialist inter alia, opinion inter alia revealed, my lord. The last para, my lord, I am not the psychiatrist.
So where is the
RIT.
uniform guideline? What is the
My lord, it's a mental disorder, my lord, and
It's not a mental disorder.
Arey
my
bhai,
lord.
let me finish.
please
Then
wait,
you say,
please wait. We are asking him. Where is the what is the procedural infirmity as per the guideline?
Guidelines. My lord, they have
Uniform guidelines of which date? 20 May 2015.
2021, my lord. This is the same guideline which they had quoted during their.
So according to you, there is a procedural infirmity. What is that procedural
It
infirmity?
is, my lord, it is absolutely silent. What my contention before my lord is that
Regarding which finding?
firstly, my point number one is that when the medical examination test was conducted by the said psychiatrist, it was conducted through her own mobile phone, which is her personal mobile phone. So whether there is any guidelines, suppose I am conducting a test, so can a doctor or the psychiatrist use his or her personal mobile phone? First point was that she was shown certain pictures, certain words. Based on that, she was assessed. There has to be a closed room. There has to be a projector. With that, it has to be shown. So, firstly, I had challenged the SOP and the guidelines regarding the use of the personal mobile phone. Second point, my lord, that these are not the self-inflicted injuries. In the page number 15 itself, the review medical examination says these are the multiple hesitation mark, and the report of the psychiatrist also says clinically normal. Physician opinion, clinically normal.
General physician.
And
opinion.
thereafter, my lord, I got myself medically examined in a government hospital, which I have attached through the supplementary. My lord will kindly see. All my reports are normal. Psychological test finding reveal no significant psychopathology in the client currently. So psychologically, I do not have any problem. These are not the self-inflicted. In my review medical examination, how they come to know, and these are, my lord will kindly appreciate, these are the stretch mark and the cut mark. It is not a hesitation mark. There are cut marks on the thighs also. She is a sports girl. She has participated in various activities. These are a skin mark, stretch mark, and the cut marks, which they have classified as a hesitation mark. Simply having cut marks, my lord will
in the wrist, my lord.
Wrist, yes, it may happen. It is a cut mark. It is not a series. It is not a series of
all right. Multiple hesitations.
What is multiple? How many? It is not multiple. It is not self-inflicted. That is there before I am not.
We are not saying
And
it is
it is not-
self-inflicted. It is the report of the psychiatrist who is determining
If it is not
that there is
self-inflicted,
an adjustment disorder, my lord.
if it is
It's not
not
considered-
self-inflicted,
You are speaking side by side.
my lord,
You expect us to
My lord, my lord, my lord.
appreciate it.
Sorry.
Yes.
Extremely
but
sorry.
if it is self-inflicted, my lord,
That's all right. How many times you will say the same thing? So you have said it's not self-inflicted. You have said that the test was not done properly.
as per the letdown SOP,
No, you are asking, not showing any procedure.
my lord, they are silent about it.
So therefore, what procedure?
My lord,
You can't say both. That there is no procedure and there is a
my
procedure
lord,
violation.
they are supposed to give.
You say that it can't be done like this. There is no procedure pointed out being violated. We asked you to show.
My
Yes,
lord will
now what
kindly
you have to show.
appreciate there is nothing.
So then there is nothing. Why should we see it? Yes.
My lord. Due consideration was taken of his. The appellant was considered in review medical board by the
In the uniform guideline, RIT adjustment disorder is defined.
Yes.
Please show us where it is
My lord,
defined.
kindly come to the report, my lord. My report, my lord.
We don't want to see your report. We want to see the uniform guideline.
Yes, my lord.
Uniform guideline.
Yeah, I'm giving.
Yes, I said.
Whether it is a condition which
Yes, mental disorder, my lord.
we just want to know.
Page,
We are not aware, therefore we are asking.
page 7, then. Page 7.
General guidelines.
Page 7. Clause 6, my lord. Subclause 16, my lord.
16. Mental or nervous instability. अच्छा.
एक बार आप दिखाइए, एक बार दीजिए. My lord, in addition to that, my lord, I can also rely upon the clause 2F, my lord. 2H. My lord, kindly come to page 4, my lord, of the medical guidelines, my lord. 2H. He is not fit, my lord.
My lord, just saying by he is not fit, let it be interpreted.
Where this adjustment disorder is enumerated.
My lord, that is a mental disorder, my lord.
What is it? We are.
And my lord, kindly come to my lord, page 6, my lord, clause 6, subclause 16, my lord. Mental or nervous instability, evidence of nervous instability, my lord.
Which is further elaborated.
16.
Yes, my lord. 616, my lord. And it can be only decided by the psychiatrist, my lord. And we have obtained the expert report of the psychiatrist also, my lord.
Where is that report?
My lord, we are saying, my lord, that report, psychiatrist report, my lord, we are saying that, my lord, orthopedic surgeon, dermatologist, psychiatrist, and general physician for expert evaluation, my lord. Actually, my lord, I think, my lord, that report, my lord, RME is considered with these experts, my lord, most probably, my lord.
No separate examination has been conducted, my lord, and the further it has been elaborated in paragraph number 11, miscellaneous conditions, general guideline. My lord, in the paragraphs 11 and subparagraph 5, evidence of nervous.
Yes, my lord, it is there.
Stability is
एक
there.
मिनट थोड़ा रुक जाइए. Let me finish. Kindly come to page, my lord. My lord, we went to the we took the petitioner to the Gauri Devi Hospital and Research Institute, my lord. Kindly come to page 31, my lord. It is not us, my lord, by a specialist of an independent body, my lord. Kindly come to page 31, my lord, of our report, my lord.
Page 31. No?
Impression, RIT, adjustment disorder.
Page 31.
No, but it has to be one of the conditions enumerated.
My lord,
in the
that is actually, it comes under mental nervousness, my lord. RIT,
we don't
adjustment
know,
disorder.
We cannot make out from this. We are unable to make out. You have not even given the full form of RIT. What is RIT? You yourself, you
My
don't.
lord, apart from that, my lord, I can also rely upon clause 2H of the guidelines, my lord. Kindly come to that, my lord. Page 4 of the guidelines, my lord, medical guidelines, my lord. 2H, my lord. What actually happens, my lord? It is not possible to give every disorder.
You have to.
My lord.
You have to.
My lord, for that, my lord,
be an impossibility.
my lord, but for that, my lord, 2H is there, my lord.
It is not there. 2H will not apply here. This is a psychiatric disorder.
Yes, ma'am.
This is not a physical disorder.
My lord,
We are
psychiatrist
trying to understand what is this RIT. You are unable to inform us.
reasonable.
You are only saying it's nervous. How do we know that it is nervous?
It's a reasonable intelligence test, my lord.
Where is that? From where? Where is that specific provision? Unless it is one of the conditions enumerated, you have so much of a discretion that anything you can make the basis of rejecting.
No, my lord.
So show us where is that?
Kindly come to page. Kindly come to 2H, my lord. 2H.
2H is nothing. It's
My lord,
about the body. It's physical. It's not about mental.
My lord, even in mental, my lord, there are so many things. It cannot be enumerated in a one particular guidelines. my
How
lord.
this? What is this RIT? We don't know. You have not said anything. You just say RIT disorder. That's all. What is this RIT? It is in relation to which of these conditions laid down in 6?
616, ma'am.
You have not even given the full form of RIT so that we can appreciate what is the finding. It is not that whatever you say. See, you are an expert body. We need not interfere. We understand that.
Yes, ma'am.
But we are required to understand what you are doing. It can't be just
Yes, ma'am.
whatever you say.
It cannot be an arbitrary.
So therefore, what have you said? Where is
As
the
far as this RIT adjustment disorder is concerned, my lord, let us come up with an particular instruction from the expert that what does it specifically means. RIT disorder, adjustment disorder, whether it relates to mental nervousness or not.
You see, come to page 8 of your report.
My lord.
Is there any such report in regard to the RME?
My lord, page 8
of your report.
Yes, my lord.
Is there such a record of the RME?
It's regarding DME, my lord. I'm not
Is
getting
there
it.
a similar record regarding RME?
Yes, my lord.
Where is that?
My lord, in the last para, my lord, actually, last page, my lord, page 34, my lord, on both the grounds, my lord. First was DME. DME was conducted, my lord, and he was rejected on the ground of number 1, page 9, my lord.
Oh, yes.
Multiple agitation.
Yes, it is there. We have
My lord,
page 30.
both the DME and RME are having the same findings, my lord.
Same finding.
It cannot be said that no, they are different, my lord. One is an expert body and another is an
Not the
apex
only,
expert
there
body.
are so many conditions. Sorry. Yes, take down. Or
My
the learned advocate for the.
My lord,
15. This matter, my lord, I appear for the employer respondent. Two appeals were preferred, one by my clients, my lord, and one by the employee also. Unfortunately, before your lordship today, only one has come, my lord, which is of the employee. My lord, my humble submission is, if your lordship hears out in the event I am successful, possibly your lordship will not have to hear out this. There was an order that both the matters should appear together.
MAT 54.
Yes, my lord.
Filed by you.
Yes, yes.
That is not on board today.
That is not on board today. But should keep it any day convenient to your lordships.
Went to the last order.
My lord has recorded, my lord, on last order, my lord, it was directed both the matters to be tagged together, my lord. It is, my lord, prior to that order, my lord, on 7 July order, my lord, directed both the matters, both the appeals to be heard together, my lord.
Order date to begin.
देखो my lord, can you consider 7 July order, my lord?
Yes, 7 July.
Yes.
27,
7
7, 7, 7. Thank you.
7 July 20. I'm grateful, my lord. Nisha August full, ne? 19. Great.
Item 16.
Lordship, I am for the Respondent Union of India.
None appears. Dismissed. Item number 16.
Item 16.
My lord, I am for the appellant.
Lordship, I intend to file the affidavit in opposition.
Lord, my affidavit in reply. My lord, I have received a copy. Yes, my lord.
Lordship, already
I've
served the
served the
copy.
reply as well.
The affidavits are taken on record.
For hearing.
24.
24. I'm grateful, your lord.
Opposition में दिलो. So to reply.
Opposition.
The 16 is
16.
Item 17.
Lordship, I'm praying for not to reveal, Lordship.
Not today. Call the next.
Item 18.
The service has not been affected.
Let service.
Publish 26th August.
Item number 19.
Lord 19, my Lord, I am for the petitioner led by Mr. Vikashanjan Bhattacharya. On behalf of him, my Lord, I am praying adjournment kindly fixed on 11th, my Lord. 11th August.
11th we cannot have. Week after that we can have it.
Then, my Lord, 12th. 12th.
After that week.
19th.
As paid.
Nisar. Richard.
Item 20.
Yes, Richard. Please talk about.
None appears.
Twenty-six.
Item 21.
21, my Lord, I am for the petitioner, my Lord. My Lord, due to subsequent development, my Lord, matter has been infructuous, my Lord. Party Uttar Pradesh. So infructuous.
What was the relief?
My Lord, relief for supplying the information under RTI Act and the code.
You have written instruction also.
Verbally instructed me, and the information which was supplied by the authority, my Lord, same was supplied to me also.
So give a printout. We'll keep it on the record.
Most of the
Item 22.
Second day.
None appears.
Item 23.
My lord, Mr. Satik Bhattacharya is on behalf of the petitioner, item number 23. My lord, he is engaged in code number 8, my lord. I'm praying for a short passover.
Not today. Not today. Lordships, may I pray only one thing? That could this matter be taken up in the coming week? Then I shall come prepared, my lord, so that it can be a doubt finded. My lord.
An adjournment is sought on behalf of.
Baro.
Great.
Grateful, my lord. Grateful, my lord. ওই দিন প্রিপারেশন নিয়ে আসবো
চলে আসবে যে মেডিয়েশন এসেছিল।
হ্যাঁ হ্যাঁ সবাই
Item 24.
I'm applying for the Public Service Commission, Lordship.
দিও না ভাই কার হয়ে রেসপন্ড
Grateful, madam.
26th August. Item number 25 to 29.
My lord, I am praying for not today, my lord. Due to illness, he could not come to us.
What are these matters?
On behalf of HON'BLE.
These are the civil defense matters, Lordship. They were the civil defense volunteers, the writ petitioners, and the applicants, Lordship. I stand corrected.
So are you prepared?
Lordship, he'll have to place his case, but I've got the rules, and the problem here was there was a process of regularization. There was a selection process for the agrokamis. They did not participate. They want regularization. Lordship, that is the only issue actually. কিন্তু ওরা নেই করবে না Oh, he's not, Lordship, the petitioner. Lordship. উনিশ তারিখ
Item number 30.
Yes.
to the petitioner.
For your clients.
Lordship, Lordship, this matter, the petitioner is not here, but it was filed on before the tribunal on the 16th of November 2025. That is all.
16 November 23.
2025 it was filed, Lordship. I just submit WPST was the date of filing, Lordship, I find.
None appears for the merit
30th মার্চের অর্ডারটা দেখেন।
Item 31.
I'm for the petitioner, my lord. I am praying for a not today.
Not today.
Item 32.
Both sides are present.
Lord, I was absent on the last occasion. I must be fair enough.
What is the date of filing of the OA?
So this was filed in May 2025. That will be apparent from the verification at page 17, 21st May. And my lord, June possibly it is the first order.
Where is your counterpart?
Not been in the corridor. I have
Mr. Rai is appearing. DN Rai.
My lord?
Mr. Rai is appearing.
Yes.
Because it is for your submission pursuant to the last order. So we don't want that in his absence. You should
Any day, my lord, keeps it.
displayed list after.
Yes. Item 33.
দেওয়া হয়নি। Lordship, I'm filing the affidavit in opposition, Lordship, reaffirmed. Reaffirmed to.
Have you served?
Lordship, not the reaffirmed, it was, I down this. It was just affirmed, Lordship.
কত থেকে দিবি এবার?
There is none to represent the writ petition.
No, no, no. Not. I'll serve. It the 23rd, no? 23.
26th August. Item 34.
34, I am for the petitioner, my lord. Last occasion, your lordship directed to instruction, my lord. That is the mercy petition before your lordship, my lord, because, my lord, so many senior citizen, my lord, for some increment, my lord, so, my lord.
Probably our বোধহয় নেই আর কি, to be re-allotted. I believe Mr. Sahasranshu Bhattacharya is appearing. আমি আর হ্যাঁ? আপনি আছেন re-allotted হয়ে ঠিক আছে আমি আছি মানে discussion এসেছেন
Somebody else's name is appearing.
No, I'm not appearing.
The Samrat Mukherjee,
Samrat,
learned AGP.
then somebody, then Samrat Mukherjee.
Yes.
Samrat Mukherjee, এটা তাহলে কোনটা করতে হবে? It's been re-allotted actually, this matter. Then
Inform him, not today.
yes.
Item number 35.
Lord, I approve on behalf of the petitioner. 35 কি সার্চ করা হয়েছে? হ্যাঁ কে আছে রাস্তাটা দেখুন দিদি আপনি কি আছেন 35-এ? আপনি কি আছেন 35-এ?
কোনো জন্য ওঠেনি। I don't think the matter has appeared, been taken up after the change, Lordship.
Sure. First,
No, it was
From the internet, my lord.
no, Lordship, you have to serve on the GP. I think let my learned friend serve
Kindly pass an order
the
so
government
that the copy of the petition is served.
now they are allotting, so all service to be the GP and he'll allot.
না না তাহলে একটা অর্ডার পাস করে দিচ্ছি যে জিপি সার্ভিসে নাহলে ওখানে নেবে না। আপনি যতটা ভালোভাবে বলছেন ওরা ততটা ভালো নয়।
আমি appear করেছি।
I do not know because I am appearing for the first time.
But we've never taken it up. Yeah, I don't have a copy. I don't
Take
have
a copy, take a copy.
I will give a copy.
Actually, hence.
Matter is adjourned 2 weeks.
promotion has to be made from the 50% roster. And if a person qualifies as a scheduled caste and and he scores a higher rank, then he will be treated as a general category. Now, Miller, this is a matter, Miller, where I find, Miller, this is a matter of great importance. I also come to learn for the first time, Miller, about this matter. I'm grateful to my.
Item number 36.
I am for the petition. I'm just praying for short passover. Mr. I was led by Mr. Short.
Your Lordship was pleased to direct my Lord collect the date of filing the original application before the London Tribunal. That was 4th December 2023. 4th December 2020.
Then you have to go before the single judge. We'll pass the same order. Yes. That order going before the single judge bench. There is an order. You take.
Here, my
Call the next.
Item number 37.
37, I am for the petitioner, my lord. Last occasion, my lord, your lordship directed them to file a affidavit, my lord. This is my reply, my lord. They have, my lord, admitted all the facts, my lord. My lord, kindly see their affidavit, my lord. And my lord, I am reply that, my lord, they have admitted person was missing, person was not traceable. My lord, no one, my lord, the name of the nominee on that ground they objected. That lady, my lord, not come forward.
Reply is taken on record for consideration for final.
The 26 order.
26.
26.
Item 38.
Yes, Lordship. 38, Lordship, I am appearing. Your Lordship, in terms of your Lordship's order dated 17/3/26, your Lordship asks report from the Lordship respondent.
এর ইনস্ট্রাকশন এনে দিয়েছে আপনাকে
Instruction দিতে বলেছে।
If I haven't gone to the papers.
আমাকে একটা কপি দেবো না?
Nothing much.
Go through it, not today.
They are having gone to the.
Not today.
Lordship, in that case, Lordship, coming week, Lordship, Monday, Lordship.
List after 1 week.
And 1 week, eh?
Lordship,
13th August.
13th August. নেই আমাকে রিপোর্ট একটা দেবেন দিদি।
রিপোর্টটা দেওয়ার মতো কিনা আমাকে তাই
না টুডে নাম দেওয়া দরকার
নামটা দিতে না
হ্যাঁ হ্যাঁ
Item
39, Lordship, I am appearing, Lordship. It is against the Lordship contempt and contempt pending, and Lordship, tribunal pass a mandatory direction, page number 133. हाँ नीलांजन এটা কি টাইম নেবেন
The draft is gone to waiting. Yes. We have to take.
There was a report was to be filed.
For which court file করার কথা ছিল।
হ্যাঁ
আগে হবে
হচ্ছে it was the opposition আর এটা কি
না না অপোজিশন না
We are informed that the report on affidavit
Appearance page. Madam, appearance. Appearance.
item 40.
My lord, I am for the petitioner, my lord. My lord, the
I am for the
advocate
public
of the
service
case is very ill, my lord. He could not come to court, my lord. My lord, kindly make it not today.
Not today.
41 same, my lord.
Yes, 40 and 41.
40 and 40.
42.
42, yes.
to Lordship, I am praying Lordship to same date be given. Lordship.
As prayed.
The 9th August.
Item 43. 43, Lordship, I am for the applicant.
43, the affidavit in opposition is ready but not affirmed yet. It should be affirmed.
Not today. Get it affirmed.
Lordship, they'll be coming next week. Lordship, their officer has not come.
Same order affidavit is in process.
Name of the added respondent, my lord.
My lord, I am for the Public Service Commission.
Perhaps not.
Let it be taken.
Yes, Lordship.
Huh? When do you want?
Monday.
As prayed, list.
Of the petitioner, my lord.
Lordship, the same mission that affidavits are ready, it has been.
Same order.
Same. Which I can
19th August. Duke Banerjee petition. Item 46.
None appears on top of the
Item 47.
Kunal appearing for the
Lord, we said Duke Banerjee is for the petitioner, my lord. I'm being informed that he is sick. Which is my kindly adjourns the matter. Should we?
46, my lord. I am for the
47.
My lord, item 46. I am for the petitioner, my lord.
40 second day.
My lord, I tender my apology, my lord.
For the other side.
My lord, Mr. Atanu Basu is for the state, my lord.
Please appear. State nobody. Today nobody is.
He is sick, has not been able to come to the court, my lord.
Mr. So and so submit.
Forty-eight.
48, Lordship. I have been, a report has been given, but I find only 2 copies. Lordship, I'll make a copy. Actually, not.
Today you will serve.
I'll serve. Lordship, I'll make. My lord, I fix tomorrow.
The learned AGP submits that.
Item 49.
But 49, Lordship, I appear for, my lord, the bearing for all the, my lord, the private respondents, total 109. Now, my lord, the earlier order was, my lord, that to file my Vokalatnama by a certain date. My lord, it has been filed. Now, bearing for, my lord, I appear for all the five.
Remain unrepresented.
But I do not know whether they will. But I think this is sufficient representations because of the fact that almost 105, my lord, I am representing. These are all, my lord, the homeopathic doctor.
Your correspondent. None appears for the writ petition.
On the ground of default, item number 22. I was pleased, bring Lordship, by the time I came here.
Somebody has appeared from the other side.
Lordship, I am told that nobody did appear.
No, let us know for sure. What is serial number?
Item number 22.
Was the other side represented?
Yes, sir, report.
Huh? Was the other side represented? We can't help it, sorry. File a restoration, mention it.
Lordship.
All the orders free. ATM orders.
Item number 58 to 60.
We have dismissed the appeals. The orders will be uploaded. There are some last minute corrections. Or rupee.
Two PM at item number 50 and 51.
ওরা না দুটো একসাথে করতে হবে
না না আমি জিজ্ঞেস
তোমার
করছি
অর্থ হয়তো ব্যক্ত করে
আসলে বললাম মন্দিরলাটা পাইনি রে আমি মন্দিরলা খুঁজে পাচ্ছি না ইলোরা আছে লর্ডশিপ সেটা করো লর্ডশিপ ইন দিস ম্যাটার Lordship, before my learned friend start, Lordship, in the first matter, I have not received any papers. I don't know whether that is
Which serial we have called?
50. 50 and 51.
Not the 2 PM matters.
2 PM. 2 PM matter. It's a 2 PM matter. It's 2 PM.
Last order is of 21/5/24.
That is why I don't understand.
The Honorable Justice Standard and my Lord Justice. And that this was meant for reserve for very judgment. By this time,
We don't have.
Yes, you had mentioned that day.
We don't have any papers.
And service has been effected even after
That
the
may
change
be,
of guards.
But that is, it is, I have, I mean.
And beloved, our clients
that
are
is-
suffering beloved, like anything. They have been
And
beloved, terminated
Lordship-
beloved, from service. Beloved, stigmatic beloved, termination without any beloved, hearing.
without inquiry.
Without inquiry.
And that to Miller, the National Human Rights Commission's observation, that was Miller treated as a dictation.
Permanent employees.
Contractual.
Lordship.
We are armed with the circulars, Miller. Miller 2011.
Lordship,
Your Lordship may have taken a different view with regard to the interpretation.
Lordship, may I make another prayer?
So can you show any judgment which extends the benefit of CCS to contractual employees?
No, it doesn't. That's
So
not
we have
our
not
case.
taken a different view. We have taken a view in a different circumstance. You are perhaps relying on something we don't know, unless we see how we can take a view regarding something which we have yet to see.
Whether Miller, my reliance on the circulars, Miller, which ensures or secures the service tenure till the period of 60 years.
Oh.
And Miller, this can be
16/9/2011.
Yes.
11, 16, 19, 20, 21.
Three circulars.
Three circulars.
See, 16/9 and then there are two later ones.
Number
9008, 1077 and which is the
9008 and 1007 are the principal circulars, Millard, which we are.
last advises the rates.
And Millard, here what happened, Millard, with the leave of my learned senior friend.
So in the last, there is some clause regarding how you are to be removed.
All, yes. Now, Miller, here there is a violation.
Stigmatic.
Stigmatic. And not only that, Miller,
Penal, it's penal.
Penal and Miller, the inquiry also, Miller, your Lordship knows, Miller. 56.
Lordship.
How we are to proceed, that we are.
Lordship, in the first.
We will not saddle you with the liability of serving again. If you have served upon change of the panel,
This matter.
Yes, we have.
you have
After the
served,
change.
then you get it from your office.
দিয়েছো? For the change.
Madam,
will be-
Submitted
Okay, but for the second matter, Lordship, I find that pleadings are complete from the order of
in
the
both.
State Administrative Tribunal, but we have only received the writ, not the affidavit.
See,
And it's not
please
annexed.
be
either.
sure that we can proceed.
That is the problem, Lordship. I
No,
had
if
to-
the whatever you have served is
I'll serve
complete,
again.
no, we are not asking you to serve again. If whatever you have served is complete, then we'll take it up.
But for my client's interest, my lord, I'll serve it.
No, we are not going to direct. You may do so if you want.
फिर भी तो complete petition है नहीं तो.
Kindly, my lord, subject to, of
That
course,
is-
my lord's kind convenience, indicate a date and time.
This is
That definitely.
going on for too long.
I know, Lordship, and Lordship in the.
You're not doing
But Lordship, we're trying our level best, Lordship.
It
Otherwise,
cannot be your best. That since May you have not been able to put your house in order. That cannot be your best.
House of cards.
houses. We've suddenly entered from a hut to a skyscraper. It's taking time, I admit. There's no way.
No liberty.
No, Millard.
Dalit pleadings ko loko diye de baba.
No, Millard.
Because what I find from the order sheet, pleadings are complete.
Hearing conclude হয়ে গেছিল।
We have got a bird's eye view of the issue. When should we fix it?
Any day which is convenient to your lordship.
13 2 p.m. 12 2 p.m.
After 12 we have
Very well,
too many
very
cases in the upcoming 2 weeks.
But my lords will kindly indicate that, no more, my lord, this, my lord,
Lordship,
adjournment business.
চাইছে
আমি চাইছি।
তোরটা চাইছে না গোয়েন্দিলা চাইছে
ইন্দ্রিলা তো নেই
Very
আমার
good.
কাছে। 27 Lordship, কিন্তু ইন্দ্রিলা চাই আমার।
গোয়েন্দিলা
আমি সব দিয়ে দিচ্ছি দিতে আপনাকে আবার my personal responsibility.
পার্সোনাল
To take too long, I get fully confused. There is some issue of WPA 22797.
There is an issue, but not
relevant.
It has been proved by my learned friend. But here, Willard, I am on a very, not a technical issue, Lordship. I am on 2 points. One is on auditorium pattern ballot, which remember I started in the morning. And
Started very early today.
Yes. What has happened, Willard? Just cursory. initially a particular incident happened where a
we could not sit at home for some other part.
prim and proper as well. Lordship, I'm just giving a cursory look as to why the impugned judgment before my lords is the judgment initially what the factual matrix says. The petitioner, the writ petitioner before the Honorable Single Judge was charged under Rule 37 for minor over a issue that a truck which had gone inside the particular area which was to be protected by him as a sentry.
CISF.
Yes, CISF. Had come out with certain scraps and it was not checked and it was. So over the incident of entrance of the truck, we charged him under 37. That is minor. That was done. The first charge sheet was memo of charge was given to him on 7th of January 2023, Lordship. Subsequently, all the hearing, every process was complied. And thereafter, we filed an order of censure under 37 to him on 14th of February 2023. Now, Lordship, what happened? He did not prefer an appeal. He accepted that order. Matter ends. Then, Lordship, what happened was further investigation was made in an issue to bring out the larger conspiracy, because one of the higher officials, because when we realized that the scrap which was taken out, there was hand of a high official also. So on a larger conspiracy, an further investigation was made, and it was found while that further investigation, certain evidences were revealed. So at that point of time, a fresh memo of charge was issued against this particular petitioner amongst others. That was a fresh memo of charge under 36.
Dated?
That was dated 22nd of February 2024. Now, Lordship, what happens is that he files a reply. That comes to a logical conclusion. That particular second charge for major punishment was challenged by them before the Honorable High Court under 226. Now, Lordship, the Honorable, not going into all the other aspects whether the charge was right, wrong, 2 points on which my writ petition was allowed in its totality. Final order was passed at the first stage of motion without giving us a chance of filing our opposition. One, why I am more on this, Lordship, because the Honorable Single Judge went and decided the matter on a wrong pretext. Here, Lordship, what we did was, the issue in the writ petition was categorically, which I will say, that first charge memo given, it came to a logical conclusion arising out of the same incident. Now, when arising out of the same incident, a second charge memo was given 1 year later under 36. So, it tantamounts to double jeopardy. Because one cannot be charged for the same offense twice. So, this is the long and short of the writ petition, what I could understand. Now, Lordship, the Honorable Single Judge, without appreciating that there was a fresh charge memo framed, there were fresh proceedings drawn up, chance of hearing was given, and it was brought to a logical conclusion. Not understanding the pretext on that particular parameter of factual matrix, the Honorable Single Judge came to a finding that it was a review under Rule 54 of the first charge memo, which was not correct. It was a fresh charge memo. And then he said that that review cannot be done by an officer it should be that review should be from an higher officer. So the entire understanding and application of Rule 54.
And this was without an opportunity.
Yes, because without adhering or without understanding the pleadings of the writ petition and not allowing us to answer the question regarding why the second charge memo was given. This is so audio alterum part. Second lordship is this, that my lords knows how there are a number of cases where 2 FIRs are registered over the self-same incident. The Honorable larger bench of the Honorable Apex Court has decided, I've got all those judgments, that the incident may be one.
Amit Baisha case, leading judgment.
And latest is 2025.
But all that is the leading judgment.
Yes. Therefore, my lord,
different versions may be there, but
yes.
there can be only one first information.
I've got that. What is for it? Therefore, I know, my lord, I am giving a cursory bird's eye view of the matter, so that I take sharing my lord's path only where my lords tell me, you show me this, because I have understood the way my lord follows, because unnecessarily going through the entire brief of 200 pages.
Yes.
And bothering your lordship's time. Now, lordships, now, my lord, so if we would have been given a chance, because the basic issue before the Honorable Single Judge was Article 20. Article 20, one cannot be punished for the same offence. So for that, the Honorable Single Judge first have to ascertain that it is the same offence or not. Secondly, whether the charge sheet is on the other aspect as has fallen from your lordships. That event can be the same, but charges may be different, arising out of the same event. So here the event was the same, where he was first charged under 37. But later on further investigation, on the same event, it came that there was a larger conspiracy. And then he was charged under 36 amongst other higher officials. Now, my lord, a question I am asking to myself. I cannot be nipped. My contention cannot be nipped into the bud, and that also when the Honorable Single Judge misdirected himself to Rule 54, which was nobody's case. That was not even a case made out in the writ petition. Rule 54 was not. Writ petition case, long and short, was this, that I cannot be condemned twice for the same offence. And then mala fide was pleaded, and other things were pleaded that I was not given. Those things I have to, once I am giving a chance to file my affidavit, all the documents on record, saying that what was till that time, I'm not saying that this particular case fits within the parameters of same event, other sections. It may fall, it may not fall. I'm not going on to that. But my lord, it is possible. It is possible, because lordship will kindly see, my lord knows, a person, for example, lordship, a person has robbed a particular article. He is charged for one offence. That article he sells to someone else. After 1 year, he is charged for another offence. One argument was being made by Dr. Sangvi in one of the PMLA cases. He was giving this example that PMLA, so one offence, but then there may have been different segments, and in service laws, it is permitted. Now, my lord, for my understanding of the subject was that if I would have given a chance to file my affidavit in opposition, I would have brought all these facts, whether it was a case of double jeopardy or not, that is secondary. But primary is Rule 54 appreciation, which was not a case made out in the writ petition. Now, lordship, I will usher my lord's part to the judgment concerned. बैठ जाओ बिटिया, खड़ा करो। ये कहते के जूनियर है चलो।
शारदा दीदी
शारदा कुछ है?
तबीयत खराब हो गई।
तबीयत खराब हो गई। Lordship will kindly come to the memorandum of appeal, lordship, so that I can usher my lord's path to the judgment as to how I have conceived. No, judgment. I mean, impugned judgment. Sir, impugned. Lordship has got 28 আমি ওই এটা দিয়ে যাচ্ছি আমার মেমোটা দিয়ে My lords will kindly take up the memo. My lord, the judgment is appended. Lordship have got it. My lords will kindly see first. The petitioner joined the Central Industrial Firm. My lord, I'm skipping that. Then, my lord, I'm coming to the same paragraph, last but one line. The relevant portion of the said order is set out here. This is with regard to the first. Therefore, I, the undersigned, have taken up the lenient view considering the length of service of the charge official and unblemished service record and in exercise of power conferred on me vide Rule 32, read with Schedule 1 and Rule 34 of CISF rules, is hereby awarded with the penalty of censure to CISF number so and so, so and so. So, Lordship, he was granted a censure that the first charge sheet culminated into this. Then Lordship will kindly come to the next page. Second paragraph. The said final order was affirmed by the higher officials after passing of the final order and in absence of an appeal being preferred against the same, the said order could not have been reopened by way of a suo motu review, that to an officer junior to the rank of the officer who have passed the order dated 14th February 2023 and the officer who affirmed the same in review. Rule 54 of CISF Rules 2001 clearly provides that the revision can be made by the authority superior to the authority making that order, imposition or enhancing any penalty even by the superior authority in terms of Rule 54 is not permissible where no penalty has been imposed. Moreover, without giving a reasonable opportunity of making a representative against the penalty proposed in the revision, is also not permissible under the rules. So, Lordship, the Honorable Judge has misdirected him in Rule 54 where there was a fresh charge memo. First charge memo. Now, Lordship, in the instant case, suo motu review is sought to be made by an authority not superior to the authority that has passed the order of. These are two different charges, two different orders passed. Two different charge memos, nothing to do with Rule 54. I will place it by way of repetition only. Lordship will kindly see. In the instance, suo motu review is sought to be made by an authority not superior to the authority that has passed the order or affirmed the same. There was no penalty imposed. It also appears that no reasonable opportunity has been provided to the petitioner. The entire proceeding, therefore, is vitiated and cannot be cured, being not in conformity with Rule 54 of CISF. Well, this is total misdirection on the factual matrix of the case. I will show from the writ petition that the writ petitioner's case was not this. This was not the writ petitioner's case. It now allows me to place the second line, the next second paragraph of that page. In the aforesaid fact and circumstances, the memo of charge dated so and so, dated 22nd February 2024, being annexure P to the writ petition, and page 57, the final order. The Honorable Single Judge comes to this finding also that he is setting aside a fresh memo of charge and a fresh order filed on that memo of charge, which is under Rule 36. He is coming to a finding that this particular proceeding is a proceeding under 54 which cannot be sustained. And then he is drawing a parallel saying that he is not the officer who could challenge it. There are two different proceedings. Now, whether the second proceeding stands on the footing of me having a salvation with those series of judgments, my lords, same event, different offences, whether second FIR can be there or not, two FIRs, lordship, whether on the same event, but if the ramifications are different. It was not a review. It was a fresh charge memo. Now, Lordship will kindly allow me to place further.
Order on record under 54.
No, my lord, I will tread by take to the. It was not the writ petitioner's case also.
54 they have placed. The respondent have placed. 54.
What happened there? I am not, because I was not there, Lordship. But I was not. What, Lordship? We go by records. We go.
I'm saying, my lord, the respondent has said the 54 shows the book, and they have shows the relevant. That is not recorded, but they have shown. I'm kindly
read something into the judgment.
anyway, my lord, I will substantiate to that, my lord.
Because
there are two things without going much into it. The Honorable Single Judge says 54 cannot be used because it is by an officer at par with the disciplinary authority.
Two
Therefore,
things.
it is not permissible.
Two things, my lord. Not that is the issue.
Just a minute. Now, holding this, he says charge memo and the order of punishment is quashed.
My lord, review.
He has not gone into the charge memo. He has not seen why the punishment was imposed. He has not seen whether there was any procedural error. And the second last paragraph you read, since the entire proceeding is found to be vitiated on the face of the record, therefore no necessity of filing affidavit, he has decided.
Lordship kindly see.
Affidavit also
The
not
Lordship
required.
kindly see 54. What is said. If it is a major penalty, then there is a provision for appeal.
No, we need not see.
But
We need not impress that.
not, that is why.
You need
that-
not impress that.
That is why the paragraph has been said, this, my lord. The 54 has been said on that ground.
All right, there is no order under 54.
No order under 54. That's why I have not prepared an appeal, my lord. I have not suo moto.
The second last paragraph, how do you sustain? Tell us. Forget about everything.
Second paragraph, my lord.
The Honorable Single Judge decides that no affidavit is required. I will decide.
No, they have not asked for any affidavits. My lord, what happened?
I'm asking you, please see when you make submissions, you don't appreciate without reference to records. You read the second
Very well, my lord.
paragraph. You read it.
Yes, I have read it.
Yes, you read it.
Lordship kindly see the first paragraph.
No, read the second last paragraph. That puts an end to everything.
The
We
same
can proceed without giving an opportunity for affidavit.
in the instant case, the suo moto review is short to
Read
be.
the second last paragraph. Since the entire proceeding
Since the entire proceeding is found to
found to be vitiated on the face of the record, the learned single judge finds. Therefore, no question of filing affidavit. Wonderful.
No, my lord, the situation is this, my lord. The person.
Just
Apart from
please
this,
sustain how it is possible.
how it possible, my lord, lordship also kindly consider the sympathetical point of view, my lord. A poor constable, my lord, what has happened, my lord? He was, lordship kindly
We are
compare
not
with
going
the,
into
lordship kindly here is the two charge sheet is there.
unless you can satisfy by any judgment that it is open to the red court to say that you will not file an affidavit.
No, that is
We have seen it.
no, that I will show you. So the to division bench judgment.
We are not going to go into that unless this is a
My lord,
judgment in
division bench,
violation
I am
of the
saying,
principle
showing
of
the
natural
larger bench.
Yeah, judgment in violation of the principle of natural justice.
Well, they have accepted this order, my lord. After the order passing of this order, my lord, they have accepted me and my record in my record, I have been put it as a censor. And after a year, my lord, they asked me to appear before the authority in respect of the same incident. Then I said, why shall I go there? Then I filed a writ application. In that writ application, what they have stated.
Again, we are saying we are not going to see anything.
No,
Why
your
without
lordship,
affidavit?
lordship will see that
Why
without
without
affidavit,
just show us
on
any
the
judgment.
face of the record, my lord,
Any judgment show us that
they cannot proceed after 37, they cannot proceed 37. After 37, proceed to 36.
has not been considered by the single.
Now 37, my lord, after passing the order under 37, they cannot proceed under 36.
Okay, you can argue this.
Lordship kindly consider this.
You cannot argue unless they have been given a chance. Cannot argue. Unless they are given a chance, you cannot argue. This is unusual. Highly unusual, to say the least. The Honorable Single Judge decides that no question of filing affidavit. I have seen it from the record. I am deciding it. Wonderful. And you are trying to sustain it.
Is it possible?
My lord, I am not trying to sustain. I am trying to sustain to their conduct, my lord.
No, there is a question.
Here, what is their conduct, my lord? When they are preferring this appeal, your lordship, when you see their authority says there is no chance to prefer an appeal in various correspondence, their opinion, there is no chance to prefer an appeal. After 1 year, after filing the writ petition, thereafter they filed this appeal to save the higher official. Why they have not preferred the appeal? Now they have come with the appeal.
There is a pending can.
Yes, my lordship, so they have submitted several documents before your lordship. Their opinion, they said, even if the Solicitor General, even everything they have said, there is no chance to prefer an appeal. But you can take a chance. I can show you the document. All
is making loud.
My lord, that is your lordship say, my conduct, how I sustain, since no opportunity.
No, not your conduct. We are not saying anything to you. We are saying how the honorable single judge can proceed like this.
My lord, if it's supposing, my lord, your lordship is correct on that issue.
Order passed in violation of principle of natural justice.
My lord, if that is so correct, my lord.
Then what is the?
That is so correct. They have implemented the order number 1.
After this order?
Yes. They have, how my record in my record censor is there.
My lord, I am he
Number one,
taking
number-
submission
no, no,
from
I'm-
the CAF. What is my appeal? If
that
he can,
be the-
whatever he can show, I take the responsibility as my lord's officer from the writ petition or from the records which is before my lords. He may say internal how he is getting information.
No,
that people were given. There was an opinion not to file an appeal. This is an internal thing. He cannot espouse for the cause
Given
of
to
the
me.
department.
That is given to person to lordship direction.
I mean, ki bolchi hai. My lord, I am on the propriety of the order, impugned order. I can show from reason enough, from which is on record, that
is the can pending for condonation.
No, condonation has already been allowed, Lord.
No, not allowed, not allowed. Not
No,
allowed. No.
Just now he said that it is pending.
No, condonation is not here. Your lordship, after my
No,
submission,
Lordship,
It is pending, therefore we are.
No, Lordship.
lordship directed bunch of document they have supplied.
No,
to
Lordship will kindly, I stand corrected, Lordship. Section 5 is there, my lord, which is can 1.
And all are in the record, my lord. Both the charge sheet are on the record in the writ petition. I don't know what more they will file affidavits.
Can 1 is our section 5.
160 days.
Lordship.
160 days, I am not standing in the way for allowing the condonation of delay, my lord. I said that the bona fide of the appeal.
Very well, so we'll hear you right now.
Yes, my lord, I'm ready.
Allow you to proceed.
Yes,
Both of you will.
my lord, may I place now?
Yes.
Yes. Now, my lord.
Application for condonation states.
Let me complete.
Let him complete
complete.
it, Your Honor.
Today I am relatively free. My lord. Let me
Yes.
complete. Let them come. I will show the judgments also. Then, my lord, let them come on. Because, my lord, next day, my lord, I will be cutting a sorry figure before, my lord, I will be stuck somewhere.
We are, Mr. Trivedi, what we are wondering is whether we should deprive you and them from a forum by taking it up as if we are hearing the writ petition. When the writ court has not considered the affidavit
That is
and
what I
not
am
considered the issue,
I am just wanting.
whether we should take it up. That's why we are asking him how he justifies that without giving an opportunity for counter affidavit.
That is, I am wanting to impress very humbly before my lords that the writ petition case was on a different footing. The decision is on 54, which has not been pleaded in the writ petition 1. Now he is saying that we made verbal submissions of the CAF before the honorable single judge, which is not on record, and therefore he went on a plenary thought of 54 and he disposed of or rather allowed the writ petition on the basis of 54, going on a wrong understanding that we have taken up the proceeding under Rule 54, which was not there. This is a fresh proceeding under Rule 36, which we are entitled to take up under all parameters of law.
Yes, you have submitted first charge memo 7/1/23 under 37.
Lordship,
for a major offence, culminated in censure of 14/2/23.
Lordship.
Second charge memo 22/2/24 under 36 for a major offence.
Lordship.
Did
And
that
then
culminated into which order?
Lordship will kindly give me a moment. That culminated into the order dated, Lordship, final order dated 24th June 2024.
And what is the punishment this time?
Nine stage down, my lord, that has been written.
From 9 scales.
9 stage down.
9.
9.
9 stays for 5 years and further 5 years increment.
For the 5 years?
Increment. Huh? For the 5 years, no increment. No increment. For the 5 years, no increment.
Reduction by 9 stages.
9 stays.
For 5 years.
For 5 years.
And then no increment for 5 years.
9 stays for lifetime.
Now, my lords, my lord has gone through the order. Now, my lord will kindly take up my stay application. Now, my lords will kindly take up page 5, the prayers of the writ petition. B prayer is, he is challenging the memorandum of charge as well as the final order. Now, my lords will kindly come to the writ petition. Writ petition starts
Which page you have shown the?
My lord will kindly come to the writ petition itself. If I'm just, my lord will kindly bear me. Starts from page 97.
The present writ petition.
My lord, it is annexed to the stay application. Why I am on? My lord, it starts from, my lord will kindly bear me. Petition mein dekho. Page 33, na? My lord, I apologize, my lord. I am trying to get well versed with this particular system, but 33 starts. Now, my lord, basically it is where I am wanting my lords to come is stay application, writ petition যেখান থেকে শুরু হচ্ছে. My lord will kindly come to page 45. My lord may start from page 44, paragraph 6. My lord will kindly see. The first inquiry they have said, paragraph 6, they are saying, subsequently, while the petitioner was posted at CISF unit DSP Durgapur, West Bengal, and on the basis of the said report dated 28/9/2022 against the incident dated 26/5/2022 happened at CISF units SMP Kolkata, he had been charged, sheeted under Rule 37. Now, my lord will kindly see the date of incident is common in both 36 and 37. That is, the date of incident is 26/5/2022. Now, he has been charged under 37 for an alleged incident dated 26/5/2022, wide memorandum number so and so dated 7/1/2023, which I cited before, my lord. That is the first charge memo. Then lordship will kindly allow me to come to the following articles of charge. CISF so and so, while posted as CISF so and so on 26/5/2022, he facilitated to enter an empty truck through Bhutgat main gate, and he also facilitated to exit, it will be exit lordship, to exit the said truck loaded with iron scrap through Bhutgat main gate during the period of 11:45 hours to 12:28 hours. The above acts on part of CISF so and so is gross irresponsibility and doubtful integrity, hence this charge. Now lordship will kindly come to the next, the final order. Your petitioner states that thereafter your petitioner made reply against the said aforesaid memorandum dated 7/1/23, that said departmental proceeding was concluded as per procedure established by law, and your petitioner had been found guilty for punishment awarded to him in form of censure in terms of the final order being so and so dated 14/2/2023. So lordship, the final order as far as this proceeding was passed on 14/2/2023. Now lordship will kindly appreciate and make a note that this the date of incident. Their contention is the date of incident is the same. Now here the proceeding culminated under Rule 37.
Yes.
Then lordship, they are saying, middle paragraph, they say that after censure. Now lordship will say, thereafter the said matter was suo motu reviewed by the learned commandant CISF unit DSP Durgapur in terms of power conferred upon him under Rule 54 so and confirmed punishment of censure on him. Now lordship, my learned friend was saying that we pleaded it, whereas it is their pleading of 54. Now lordship will come on 6/9/2023. The Deputy Commandant Arvind Kumar Singh, the respondent number 7 herein, called on your petitioner orally. This is about lordship which came to their understanding. Then lordship appeared personally in the office without any official intimidation and or letter, and he would present before the Deputy Commandant on 6/9/2023. Accordingly, as per the oral intimation, the respondent number 7, your petitioner appeared in person before the respondent number 7 at his office at 18:30 hours on 6/9/2023. The respondent number 7 took the statement about incident of 26/5/2022, which was happened at CISF unit SMPA Calcutta. For that, your petitioner already awarded punishment of censure under Rule 37 of CISF rules by the erstwhile commandant by its final order dated 14/2/2023. Then lordship will kindly come. Your petitioner says and submits that there is no such provision in CISF acts and rules that once a punishment had been reached to its logical conclusion, you cannot being a junior officer, reopen the case and took suo motu inquiry and reopened the old case and took written statement illegally, putting pressure and force without due process of law. Being a junior rank, the respondent number 7 raised questions about the integrity and ability of senior officers in run the unit erstwhile commanded, and suo motu reopened the case by conspiring against the petitioner and illegally by force took statement in writing on 6/9/2023. Now lordship will kindly come. These are the medical documents, not relevant. Now lordship will kindly come to paragraph 16 at page 50, running page 50. Here starts the story of the second charge. Milord, I am not on whether right, wrong, indifferent. I am not on that, which fell from my lodge at the very beginning without giving me a chance of hearing. Why I am that? Here, now they have pleaded not, there was a case of 54. Then they have pleaded a fresh charge sheet, charge memo, and a culmination of that order under 36. So they are two different proceedings. 37 proceeding and the order under 37 proceeding cannot be said to be a review under Rule 54. This is what I am on. This is what we were trying to bring by way of an affidavit that if you are challenging the process of double jeopardy, then I should be given a chance to show what materials were there for me to give him a fresh memo of charge.
No, whether the allegation itself was correct.
That I'm coming.
In absence of an affidavit, how a court can conclude that whatever is being said is.
My lord, what I'm, even if, my lord, there are judgments, very bleak judgments where at the very outset, the person did not have authority per se without jurisdiction. That also, lordship, if I say no to it, if I don't admit, I have to get a chance of audio. I will show, my lord.
See, these
These
submissions at the first brush look good. It may be a case where an officer, you may say, is without jurisdiction, but is there a delegation by a higher authority? There are so many things. So without an opportunity, how a court can arrive at a conclusion?
I am smiling, my lord. Whatever is falling from my lords. In 2025 latest judgment, the Honorable 3 judges bench of the Honorable Court has decided it.
Achha.
This is reported in 2025, volume 7, SCC 545. Exactly, my lord, I will place it. Therefore, that at the very outset, it is the cornerstone. You cannot do it, and taking into consideration judgments from innumerable.
The exercise of jurisdiction by the learned judge. He must be deprecating this every day. But how they are doing it without opportunity?
And this is why, beloved, I have got 3 judgments.
Maybe after that opportunity,
Yes,
he
yes.
succeeded. We don't know.
Said, Millers, that there were 2 proceedings. Their main contention was twofold. One, you cannot review, but that was not a review. Review is, if I would have reviewed my decision under 37.
But then there would be no occasion for a chargement.
Yes.
A review is.
The
review power is exercised.
Lordship.
There is a proposal to enhance the punishment, then give an opportunity.
I'm grateful.
If not, it is rejected.
I'm
There
grateful.
is a question of a second charge memo in a review.
And Millard, the best part is that when the second charge memo was given, he did not challenge that. There was a full-fledged hearing. It culminated into an order.
That does not mean anything. Ultimately, he can challenge everything.
He can challenge, but my lord will kindly look at this factual matrix in the light of the impugned judgment. Nothing more, nothing less.
Because he would have raised in his written statement of defense that I have already been proceeded against. He must have raised.
He must have. He could have.
And he should have.
Yes, my lord.
Anyone will advise him to do that.
But my lord, he has challenged the final. My lord, I am not. He is well within his rights to challenge, but I am also well within my rights.
This kind of
Because and my lords will kindly recapitulate the judgment which is impugned before my lords. It does not say anything about this 36 and 37. There are 2 different distinct charges. One is for major, one is for minor.
So therefore, they made out a case that because there is an enhancement, therefore it is a review done by an officer during absence of the competent officer. All these things they have pleaded. And just to victimize me, my family, everyone was raising a hue and cry. We don't know. He may be 100% correct.
Yes.
But without an affidavit.
I am grateful. I am grateful. There, my lord, I am that judgment which fell from my lord, starting from them, there, my lord, what I do with the first judgment, the last judgment I take. So, my lord, there also, if what has fallen from my lord, very rightly, even there is an illegality. I should be given a chance to bring on record whether there is an illegality or not. If after perusing my records, that my initiation of 37 proceeding was per se illegal, bad in law, trash it. I cannot be condemned without being heard. Because, milords, because it is not a case, milord, there are an innumerable number of judgments when on the same incident, 1961, larger bench of Supreme Court, 5 judges bench, said on that Article 20 concept, taking down and then going, ki there may be one incident.
There are line of judgments which say that double jeopardy does not strictly apply to a departmental proceeding.
That was, well, my lord, it becomes so easy for me. Because what is falling from my lord, I learn it by burning the midnight oil. Because some subjects for me are new, Lordship. So, my lords will kindly see the judgment which I am saying, that Lordship I will not take much time, another 5 minutes or 10 minutes by the clock, then because my lord, whatever I am trying to show to my lord has already perceived. My lords have already perceived. So, my lord, I was just saying that what was the admission. Then my lords will kindly see paragraph 16. He is saying, your petitioner state that by misusing his rank and file, the respondent number 7 influencing the present superior authority suo moto reopen the case by issuing fresh charge sheet. Now, my lord, issuing fresh charge sheet, he was well within his rights, because that does not tantamount to hierarchy. Because if it is a fresh charge memo, but the Honorable Single Judge said that this fresh charge memo he cannot issue, taking the plea of 54.
He did not say that also. He said this 54 is not maintainable,
Yes.
charge memo and order quashed.
Yes, my lord, that is what I am on.
He has not even said that it
Yes.
cannot be done by this
Yes.
authority.
Yes, my lord. So now, that's what I am trying to show. What was the case at hand, which was not only I was not given a chance of hearing. That is one aspect. Even the case made by the petitioner was not properly deliberated upon to come to a reasoned finding. And I was just, things were just set aside. Then Lordship will kindly see, then my lords will kindly see paragraph 17. Thereafter, your petitioner submitted his reply. Paragraph 17, Lordship, page 50. Thereafter, petitioner submitted reply dated 11/3/2024 against the charge sheet dated 22/2/2024, denying the allegations leveled against him inter alia, stating that the fresh charge memo dated 22/2/2024 is bad in law, illegal and without any jurisdiction, and suffered from serious prejudicial lapses and delay. Your petitioner states that thereafter, paragraph 18. In terms of the order dated 23/2024 passed by the respondent number 5, the respondent number 6 had been appointed the inquiry officer. Then preliminary hearing was done. Then Lordship will kindly come. Letter of inquiry, then reply, my lords, and then after that now Lordship will kindly appreciate that this is the case made out by them. So, my lord, 2 cases are made out by them. That it was a review, which was not there. When as soon as a fresh charge memo is given, the question of 54 does not come. And when a fresh charge memo is there, he has taken a point of double jeopardy. Now, taking that point of double jeopardy, Lordship, first I will cite the recent judgment.
There's the punishment order dated 24/6/24. Which page, please?
My lord, 20.
Second punishment order.
My lord, I'm just coming. Memo charge, Jagat. My lord will kindly bear me. No, impugned order done. I'm bolchi.
215. Yes, got it.
Got it, Lordship?
215. 215.
Lordship. ऐसा टाइप कर दिया कुछ दिखाई नहीं पड़ रहा, ऐसा स्कैन करके कुछ हमको दिखाई नहीं पड़ रहा. My lord, I apologize.
Yes, yes.
This year, the scan copy says I cannot see anything. My lord, kindly allow me. So 215 is the final order.
Yes, it's at 2:15. We have seen it.
Lordship, this is it. Now, my lords, I recuperate. My lord, it is the order which takes into consideration many things, Lordship.
It's
Now,
a
my lord,
long order. It's a long order.
long order, my lord, rightly, wrongly, indifferently, my lord, we have done something. Now we need to go place all records, and the honorable single judge will have to deliberate.
Correct. It has to be
And-
considered.
And
See,
there will be
in your WS to the second charge memo, see paragraph 2. Page 101, paragraph 2. Your specific case that there is a second charge memo. And before the High Court, you are saying it is a review. No affidavit. Above everything, no affidavit. Not only no affidavit, the court says no affidavit not required.
So, my lord, should I place the judgment with regard to audio alterum partum first?
Yes, give whichever you want.
And my lord, with the second memo. Now, my lord, audio alterum partum, because that is, my lord, this is, my lord, আমি দিয়েছি দাদা 2025-7 SCC 545 हम मुझसे पढ़ लेंगे दादा को दे देंगे दादा my lords will kindly the longest judgment my lords will kindly see it is a larger bench judgment honorable three judges. Now my lords will kindly take paragraph 42 which starts at page 25. My lord, here, my lords, the honorable court has taken into consideration series of judgments, my lord. What my lord is saying, and it culminates at paragraph 50. My lord, paragraph 50. Honorable 5 judges bench judgment has been quoted on audio alterum partum, which says, my lord, paragraph 50, my lord, then I'll come to paragraph, because this is the paragraph 50, my lord. The object of observing the principles of natural justice is to ensure that every person whose rights are going to be affected by the proposed action gets a fair hearing. The non-observation of natural justice is itself a prejudice to any person who has been denied justice, depending on the facts and circumstances of each case. The principle of procedural fairness is rooted in the principle of the rule of law and good governance. In so and so, the court held that requirement of procedural fairness holds an inherent value in itself. Now, my lords will kindly see another paragraph which I am trying to impress upon my lords. It's paragraph 43, which is at page 26. The opportunity of hearing is considered so fundamental to any civilized legal system that the courts have read the principles of natural justice into an enactment to save it from being declared unconstitutional or procedural grounds. But we kindly see in all our service laws, we have this statutory provisions. It has been argued before us that if the failure to provide hearing does not cause prejudice, observing the principles of natural justice may not be necessary. What had fallen? What I was telling my lord, and my lord told me, no, this is not. That is why, my lord, I felt jubilant just to tell my lord, this is the paragraph, my lord. It is argued that failure to provide hearing does not cause prejudice. Observing the principles of natural justice may not be necessary. In this context, the 3 judges bench of the court in S.L. Kapoor versus Jagmohan speaking through Chinnappa Reddy considered such argument as be pernicious and held that the non-observance of natural justice is itself prejudice to any man and proof of prejudice independently of proof of any denial of natural justice is unnecessary. The Supreme Court, however, has drawn out an exception where an admitted and undisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible. Then the court may not compel the observation. This is the car, but my lord, this is not our case. Then Lordship will kindly see paragraph 46. The Supreme Court observed that where an inquiry is not convened by the statutory provisions and the only obligation of administrative authority is to observe the principles of natural justice, the court tribunal should make a distinction between a total violation of rule of fair hearing and violation of facets of law. In other words, the distinction must be made between no opportunity or no adequate opportunity. Now, Lordship, we have got here no opportunity, adequate, leave out adequate. In the case of the former, the order passed would undoubtedly be invalid and the authority may be asked to conduct a proceeding afresh according to the rule of fair hearing. But in the later case, the effect of violation of the facet of the rule of fair hearing has to be examined from the standpoint of prejudice. Now, Lordship will kindly see. Well, there are a series of judgments, may have a cursory look. Well, this is what has been decided by the Honorable Supreme Court. Now, Lordship, I come to the second aspect about double jeopardy. At the first stage, the Honorable Single Judge cannot come to this finding that just because the date or the occurrence is one, there cannot be two inquiries or there cannot be two memos under 36 and 37 respectively. Why, Lordships? Well, that 61, what is? Yes. Now, Lordship, again, Milord, why the Honorable Single Judge ought to have, in my respectful submission, taken on record the affidavit in opposition, reason being, Milords, because even what has fallen from my lords, that in civil there are judgments which my lord knows that in service laws it is permissible. And here, my lord, even taking double jeopardy, Lordship, my lords ke diye na. 2025 SCC online SC 358. My lords may take up 8 point. My lord, it starts from 8.1. That is at page 4. My lords have got it. My lord will kindly take into consideration the underlined portion. Underlined portion registered for the same offense. However, where the incident is separate, offenses are similar or different, or even where the subsequent crime is of such magnitude that it does not fall within the ambit and scope of the FIR recorded first, then the second FIR could be registered. Then, Lordship, the second, underline. These safeguards can be safely deduced from the principle akin to double jeopardy, rule of fair investigation, and further to prevent abuse of power by investigating authorities or police. Thereafter, second FIR of same cannot be registered. Now, Lordship, why I am coming? This starts. Now, my lord will kindly come to 8.3, which is on the next page. The position regarding the second FIR has been clarified by a 3-judge bench of the court in Upkar Singh versus Ved Prakash. The relevant discussion made in the judgment is extracted herein below for ready reference. From the above, it is clear that even in regard to a complaint arising out of a complaint on further investigation, if it was found that there was a larger conspiracy, then the one referred to in the previous complaint, then the further investigation under the court culminating into another complaint is permissible. On a perusal of the judgment of this court in so and so also shows that even in cases where a prior complaint is already registered a counter complaint is permissible, but it goes further to hold that even cases where the first complaint is registered, the investigation initiated, it is possible to file further complaints by the same complainant based on the materials gathered during the course of investigation. Now, Lordship, 8.4. In such a case, the court has to examine the facts and circumstances giving rise to both the FIRs, and the test of sameness is to be applied to find out whether both the FIRs relate to the same incident in respect of the same occurrence, or are in regard to the incident which are two or more parts of the same transaction. If the answer is an affirmative, the second FIR is liable to be quashed. However, in case the contrary is proved, where the version in the second FIR is different and they are in respect of two different incidences or crime, the second FIR is permissible. In case in respect of the same incident, the accused in the first FIR comes forward with a different version or counter claim, investigation on both FIRs has to be conducted. Then Lordship, 8.5 is also very important. Nirmal Singh Kaulan versus State of Punjab, this court held in the following terms that when a new discovery is made, the second FIR would be maintainable. Here, beloved, there is a new discovery. It is said as follows that the second FIR, in our opinion, would be maintainable not only because there were different versions, but when new discovery is made on factual foundation, discoveries may be made by the police authorities at a subsequent stage. Discovery about a larger conspiracy can also surface in another proceeding, as, for example, in a case of this nature, if the police authorities did not make a fair investigation and left out conspiracy aspects of the matter from the purview of its investigation. In our opinion, as and when the same is surfaced, it was open to the state and or the High Court to direct investigation in respect of an offence which is distinct and separate from the one which the FIR has already lodged. Then Lordship, 9.9 is very important, where I am relying on 9.2, 9.3, 9.4, which is the ratio. 9.2 is when the ambit of the two FIRs is different, even though they may arise from the same set of circumstances. So, Lordship, it's the same set of circumstances here. The first charge memo and second charge, it is allowed. If the investigation and or other avenues reveal that the earlier FIR or set of facts to be part of a larger conspiracy, when the investigation and or persons related to the incident bring to light hitherto unknown facts or circumstances. Now, Lordship will kindly allow me to place paragraph 10. Last but 4 lines. The FIR in proper point of time refers to a particular incident and the action taken therein is limited. The second FIR pertains to a larger issue of widespread corruption in the concerned department and therefore in much larger in scope than the previous FIR. Quashing of the FIR would nip the investigation into such corruption in the bud. The same would be against the interest of justice. Then, Lordship, I will hand over the 9, which I suppose my Lord was pointing at. 1961, larger than 5 judges bench, which is on this double jeopardy. My Lord, I will hand it over. My Lord, may just make a note. It is paragraph 6, 7, and 8, Lordships. I will not place it in third. My Lord's nose, my Lord. Stop the My Lord, I'm just requesting or am I beseeching your lordships? 1960 SCC online, Supreme Court, page 56. State of Bombay versus SL Apte and others. 1960, page 656. Lordship, this is on the same point, Lordship. My lords will kindly see page 6, 7, and 8. Paragraph is it's an old judgment, so they have not 6, 7. That is 6, 7, and 8, my lord. That ratio of double jeopardy and thing are there, my lords. So, my lord, in my respectful, my lord, may May I place it just if my lord so. My lord will kindly allow me to come to page 7 and allow me to place the second paragraph. My lord, because no other matters can be taken up. So, my lord, I am taking 5 more minutes of my
Yes,
lord.
yes.
My lord, second paragraph, that portion which has been carved out. This court has recently held in Om Prakash Gupta versus State of UP that the offence of criminal misconduct punishable under Section 5(2) of Prevention of Corruption Act is not identical in essence. Import and contents with an offence under Section 409 of the Indian Penal Code. In view of the above pronouncement, the view taken by the learned judge of the High Court that the two offences are one and the same is wrong, and if that is so, there can be no objection to the trial and conviction under Section 409 of Indian Penal Code, even if the respondent has been acquitted of an offence under Section 5(2) of the Prevention of Corruption Act. The High Court also relied on Article 20 of the Constitution for the order of acquittal, but that article cannot apply because the respondent was not prosecuted after he had already been tried and acquitted for the same offence in an early trial, and therefore it is well known maxim so and so, no man shall be tried. It appears to the court that it is for one and the same cause embodied in Article 20 cannot apply. Before leaving this part of the case, we might also point out that a similar view of scope of rule as to double jeopardy has always been taken by the courts in America. The word of the Fifth Amendment, there is a rule is to be found that the American Constitution are, nor shall any person be subject for the same offence to be twice, but in jeopardy of life and limb. Now, Lordship, I will come to the next page. The cases may occur in which the same act may render the actor guilty of two distinct offences. In such cases, the accused cannot plead trial and acquittal or conviction and punishment for one offence is in bar to the conviction for the other offence. This is what I am on. Then, Lordship, there is a claim of violation of the Fifth Amendment, the carved out portion, by the imposition of double punishment. The contention rests upon the following facts. Of the 9 counts in the information, 4 charged illegal possession of liquor, 4 illegal sale, and 1 maintaining a common nuisance. The contention is that there was double punishment because the liquor which the defendant were convicted of having sold is the same that they were convicted for having possessed. Now, my lord, here what I was trying to tell, my lords.
Yes, we have gone through it. So what he is saying is that how I can sell it unless I possess. So possession cannot be a.
This is what I'm saying. So separate. So now they are saying since the truck came out on one particular day, and for that truck coming out over there, I was charged under 37. Now that truck coming out with scrap, it was deciphered maybe by you later, and my role was deciphered by you maybe later, but that is double jeopardy.
In the first instance, there was no allegation of it being loaded with scrap.
My lord, my lord, I will go.
No, what is the distinction between the two charges?
My lord,
you have not
my lord, it was iron scraps. It was, lordship. Later it was loaded with iron scraps. One. Secondly, it was that certain larger conspiracy of there. We have also got in our Amit
72 and 97.
Now,
we'll hear you. We will hear you.
Now, it was noted there was high officials who were involved, and there were tampering of documents. Certain files went missing, just misplaced. So, there are array of charges. Only thing which is common that I can vouch as my lord's officer, that it was the incident that coming out of the truck coming out of the gate.
So, according to you, the attending circumstances revealed later. This is what you are trying to say.
Yes, my lord. I am.
What was initially perceived as a truck stray coming out with scrap.
Yes.
Later on, we discovered that there was a big conspiracy.
And that departure we have categorically stated in our final order. That final order may be wrong, but I need to prove it. My lord, what we are on a larger conspiracy, but my lord, what I am on, without delving into the factual matrix of the case, I am saying, I am not championing for the cause that whether the order which has been passed is good, bad, or indifferent. I am on the propriety of the order of the judgment impugned before my lords. That is it. Give me if had I been given a chance, things would have been deliberated upon. It would have been a speaking order on the basis taking vis-a-vis both the orders, the findings. Then, my lords, these judgments would not have come to my rescue. But as of now, on the pedestal where I stand, I am strengthened by these judgments because, Lordship, there was a total departure and non-appreciation of facts.
Very well. We'll record your submission and he will hear him on the next. The learned ASG. Take down. The learned ASG.